Welcome, everybody. I would just like to clarify that this is not a gift of truth or euro presentation. It is a friendly discussion between members of the study group. The Zoom is being recorded. It will be uploaded onto the Telegram study group. So please don't share any private or personal details. All names will be edited out. For everyone's benefit, also, we just request that you please stay on topic, and we'll open the floor to questions towards the end of the discussion. I hope you have a wonderful evening, and I would like to hand the floor over to Aubrey and to James.
Okay. Hi, good evening, everybody, and yes, welcome to tonight's discussion. James, hi, how are you?
I'm good, thanks. But yeah, everything's good here in New Zealand. Good to be back with you guys. I'm not sure where we're going to take this today, but Aubrey and I have just started discussing one of your members' success that he had in January and his paperwork, and basically what's happened with I think it's Standard Bank at the moment, in that they've indicated that they have written off his business's overdraft, which he had, and are now intimating that they're coming after him in his private capacity for the debt, which is a load of nonsense. It's absolute misrepresentation of the fact. In fact, it constitutes criminal coercion now. We have a law in New Zealand under the Criminal Act 1961, which deals with trying to gain financially using misrepresentation, which is a crime. You go to jail for it. So you should be able to find something similar, I believe, within the South African context, where you have somebody trying to use criminal coercion to go after you after having settled a debt in the manner that this chap did with his bank overdraft for his company, because as a director, he is liable for the company's debt in any event. A company cannot pay its own debt. It's only an entity. It's a vehicle. It's a vessel. And so the directors are always liable for the debts of a company. And that's the nature of how it's set up. It's the same as a trust. The trustees are liable for the debts of the trust. So having said that, I would say that he's got to contact them and let them know that he has the right at law to settle the debt as a director, being the liable party, which he's done so honorably, and put them on notice that they are now acting dishonorably, and should they in any way attempt to coerce further currency out of him for the debt having already been settled, that he has the right to sue them. Not only I think it's this lawyer that deals with Standard Bank. He seems to be quite a piece of work, but him in his private capacity, as well as the bank in their corporate capacity, for the maximum allowable at law. He could probably get an advocate to assist him and not have to do it on his own, because this is just a basic, straightforward civil action, and then have an agreement with an advocate to basically share in the spoil, so to speak. Almost not a pro bono setup, but if you sue the bank for 100 million or whatever you choose, then he gets a fair portion of the proceeds.
Right. Yes.
That's what I would do. These guys are so used to calling the shots that even through a small claims court, you can do that in South Africa, and you can put that through the courts immediately. You become the appellant, the applicant in the matter, and you sue that lawyer, Yarp, I think his name is, if I remember correctly. But you sue that lawyer in his You sue him in his private capacity, get him before a court, small claims court, immediately for dishonor. He has no right in law, one, to intimidate you. There's a law against intimidation, and what he's doing constitutes not only intimidation but criminal coercion. So you put him on the back foot. You, the applicant, you ask the questions, and he's there. He's got to go into the box like a normal criminal would, basically. And you get to ask the questions, and the questions are going to be very simple. One, is the bill of exchange that you provided a valid means of settling a financial obligation? Yes, it is. The law stands, and it's valid. To this day, it's valid. In your law and in any law around the country, because we're all governed by the UCC. Uniform Commercial Code governs all commerce, and your acts and statutes relative to bills of exchange will reflect that. It can't be averse to it. It can't be different to it, because the Uniform Commercial Code is uniform. across all spheres. It's like pilots in an aeroplane that fly for Pan Am or whoever. They all have a certain protocol that they have to operate under, so that it governs commercial flights uniformly around the world, because everybody's landing in everybody else's country. It's the same thing with commerce. So these UCC protocols that are in place to govern commerce are a standardization that governs all country, all banks, all commerce are all subject to it. So that's what I would do. I would sue him immediately by this guy. And you guys can, I think, do it for about 200,000 Rand, I think it is, in the small claims court. Not a small claims court, but in a magistrate's court, so that you can defend yourself. You don't need an advocate or anything. But if you're wanting to run for a larger volume of money, well, then you need to do it through a high court setup, and you need to do it with a competent advocate who would be willing to take on the matter, because you got to remember they're all part of the same club.
Yeah,
and
for sure.
So you've got to know how to keep that advocate on the straight and narrow, and you know how to keep his feet to the fire, so to speak, because he will capitulate on you to save the very system that he is sworn to uphold long before he does what is right by you. So that would be the process. And also his bill, you don't pay his bill out of cash or anything like that. You pay his bill with a bill of exchange.
That can be settled, yes.
Yes, and you can actually, because a court is both a bank, a post office, and a court, and a judge wears all three hats in a judicial setup. You can give him the bill of exchange. You can use the court system to pay him and tell him to take it before the court and get settlement of the matter. And if you are ever in a court setting as well, you can also ask that the judge compel performance of another party, like a bank, like this Europe character. You can compel, if they haven't already, you can ask the court either compel performance that they perform, or to settle on behalf of, because the court is also a bank and the judge is a banker. All right, that wraps up that little scenario. Any questions relative to that before we pick another subject and move on? Abri, I'm all ears.
Hi, I've just got a query regarding that. If we have a different approach to this BOE, doing a secured party creditor filing, wouldn't that give them sort of a different approach to our filing our BOE in terms of setting off our actual debt?
All right, if I'm going to answer it for you, are you talking about filing like a UCC1? Is that what you're talking about, Ilani?
Yeah, that's exactly it.
Not everybody has filed the UCC1 or is au fait with having filed the UCC1 to become a secured party creditor. But although there is justification and it's warranted and it's usable, it's still not important. What you're doing in this whole setup is you're just understanding that you are the beneficiary of the estate or the trust that they created. You're a beneficiary, an equal beneficiary, and a signatory to that account, that estate. So even without filing or having the competency to have filed the UCC1 and the understanding surrounding that becoming a secured party creditor, you are still, it doesn't take away from the fact that you're still a beneficiary and a signatory to that account. So when you understand that everything that comes in the post from any governmental organization, councils or municipalities or whatever the case may be, they're always only referring to your trust. And there's a multiplicity of ways that they do that, because there's many variations of your all capitalized name. It could be your first, second, and family name, all of them in all caps, like you would have on your driver's license or your bank card, or it could be Miss, Mrs., whatever your surname is, or abbreviations to it, but they are only ever referring to your estate. So when you understand that and you accept that obligation as the signatory, as the accommodating party to that estate, then you can accept a financial obligation on behalf of that trust, authorize it, accept it, date it, authorize it, and return it for settlement. So you don't need to have the expertise or the knowledge on filing a UCC one. Yes, it's good because it gives you a greater understanding and it also brings to light the importance of the UCC. But it's neither here nor there as far as accepting an obligation on behalf of the trust. You're still the beneficiary, if that makes sense.
Yes, yes.
All you are doing when you file the UCC one is you're showing that you have done your due diligence, you have looked into the matter further, you understand that it's they refer to you as a transmitting utility, etc., etc. But that's it. It's just greater understanding as to how they've set up this corporate structure that governs us, that we're bound to, and they hold us as surety for the debts of those estates that they've created. It's just a matter of you understanding that and then releasing yourself from it in as far as you don't accept liability as the living woman or the living man. You only accept liability as the accommodating party. And you'll find within your laws, probably within your Bills of Exchange Act as well, they will also refer to acceptance as an accommodating party and things like that. And when you've signed it under condition of UCC 1-308, well, if you read that, you should know that off by heart. It basically indemnifies you against any form of private liability. So it's the same as sans recourse. You have no liability relative to that instrument that you've created to set off the debt. All it is an authority to act, and then they as public trustees are obligated to fulfill their portion or their obligated part and settle the matter in line with the law, because you fulfilled your obligations to the exact letter of the law.
You're referring to Section 24 of our Act, which talks about signing in the capacity of an agent. When you sign as the agent, then on behalf of the principal, you sign in a specific manner, and then you have no personal liability on the instrument.
Correct. So that would be, for instance, I would sign my bills of exchange, and up the top right, I would have an accepted process in black pen, all caps, in inverted commas. That's where I'm signing as the accommodating party. I'm accepting it, not in my private capacity, because it's in inverted commas, it's all capitalized, it's black, it's in the realm of the dead. But I've dated it and I've signed it in my normal manner, but beneath my signature I've written UCC 1-308, which is the same as like non-assumptive, but it's the same thing. It's sans recourse, same kind of thing. They all meaning the same kind of thing, that I don't accept private liability for my signature going onto this instrument. I'm doing so as an agent for, or as we know, we are, as an agent, we are the beneficiary of this estate. We are the signatory to it. We're equal beneficiaries because the state created the trust or the estate. They created it. So they benefit and we benefit. So we're equal beneficiaries to the all caps derivative of our name that's created this estate. We're not the sole beneficiary, we equal beneficiaries, but we are the signatory to it. And without our signatory, they can do diddly squat. Our signatory is what releases the embedded equity in any presentment. So the bank sends you a bill, that's an offer to contract. It's a presentment. And your signature releases the embedded equity that's in that presentment.
Yes.
So you perfect that gift, send it back to them, and it's a done deal. For them not to honor it is to violate not only international law, it's our local acts and statutes which bind them. I mean, just remember, the acts and statutes don't bind you. You're a living man, a living woman, unless you consent to it. But in all aspects, they bind the crown. It binds them, the public trustees.
Right.
Hi, everyone. So I've got an interesting question with regards to Absa Bank. I got someone ask me or send me through a response for a bill of exchange that was tendered. And the response on the line, the response says, kindly request the member to send us proof of the debit to their account in lieu of the bill of exchange sent to Absa. Our fraud department is not comfortable with the documents provided.
All right. Okay. We've had the same issue here. Okay. Perfect. So this is how they intimidate you. When they say their fraud department is not comfortable, you see very clearly they're not claiming that it's fraud. They're just intimating, our fraud department's not comfortable. Now, I could give a shite how comfortable they are or they are not. I don't care, and neither should you. The bottom line is this: you immediately reply, and you say, well, first of all, on the face of it, it looks like you're trying to intimidate me with the use of the words fraud or possible fraud, or your fraud department is not comfortable. Can you please get your fraud department to indicate what the material defect or fraudulent construct is of the bill of exchange that they have received? So you you ask them, you say, right, you intimated that your fraud department possibly feels that this is a fraudulent document. I require that they reflect what is fraudulent in this document. Or if you cannot, you accept the fact that it is a valid, legal, financial, negotiable instrument. And you put them on notice that you don't accept intimidation or nuisance. You have fulfilled your obligation to the exact letter of the law. They are now compelled to do the same as public trustees in this matter and to process the bill in an honorable manner, period.
Okay, and this would obviously account for any bill of exchange that you tendered to a corporate, to a company that is registered in South Africa. So it's not necessarily to the bank. So let's say I've got a medical aid that I'm trying to discharge now, the monthly payments. This would fall in the same category. One would answer the same.
Yes, basically you would, but you always got to remember, when you're not dealing with a bank and you're dealing with a third-party entity, like we've had some people try to settle rentals or something with a rental agreement or school fees or something. But as soon as you're dealing with a third-party entity and not directly with a bank, it always makes it a bit more difficult, because the banks then act as gatekeepers and are not acting in honor. They're quite happy to process bills of exchange in a number of instances that they issue the bill for. They'll issue a bill and say you owe them X amount, and then you provide them a promissory note or a bill of exchange, and they set off that debt. They sell on that note into the system, process it through Treasury, and they get their currency. So they're happy to do that with their own bills that they issue, but they don't want us doing that with third-party entities, because they feel that this realm, even though we now know what to do with it, we can't push the parcel, and they're going to try and act as gatekeepers. Well, there's no law that allows them to have the monopoly to choose what and when and how. They don't have that. They don't have that in law. There's no law that says only the banks can act as gatekeepers and only the banks can process bills of exchange and put you into, or your whoever issued you the bill, and put them into currency. There's no such thing, but they do that because they don't want us to benefit in the manner that we do. That's that simple. So we need to hold them liable. That's why you guys have got to realize that most of these issues, and they're going to start fighting this now. They would rather fight you, every single one of you, in doing this, and this becomes a mainstream. Why? Because this literally is the Pandora box of settlement, and it's going to have to go through a court system, a legal system, and you guys are obviously here for a reason, and there are going to be some of you that are going to have to go through a court process, go through a small claims kind of setup, and sue the bank. You get that chief financial officer to, how many, there's 50 of you guys that are doing the same process against these bankers, and not just one or two, 50 of you. You're all settling them with the banks, and you open 50 separate cases against those entities, this lawyer Europe, whatever his name is, and you sue from wherever you are in the country, Durban, PE, Cape Town, Joburg, doesn't matter. And this sock puppet's got to go to court. How long is he going to be able to maintain that? He's not going to. And that's what you do. You use the same yardstick to beat them into submission that they used to beat us into submission.
But you've got to beat them to court first before they beat you to court.
Right.
That's
So
the
how's that? So how is that? How do you do that? As soon as they intimate or even murmur, like in your thing with ABSA fraud, you say, right, you put them on notice. I want to know, you've got 10 days to furnish me with details as to why you are trying to intimidate me in the manner that you have in your last correspondence. You're inferring that the document you've been provided, this financial instrument, is somehow fraudulent. I take umbrage to that fact. I'm putting you on notice that if you can't provide me with material evidence to your intimation, I'm going to sue you in your private capacity and your bank for the maximum allowable in law. You've got 10 days to furnish me this detail. That's it. So now they're on notice. You give them 10 days. If they haven't, you give them a further 10 days. If they, it's normally the banking process is 30, 15, and 10. But you could do 10, 10, and 10. And then you take those documents where they haven't provided you with it, and you include an invoice for their account if they can't provide you the detail. And it could be a bill for 200,000 Rand. So you create an invoice to them. You send them an invoice. Right, here's your invoice. If you can't provide me with material evidence as to your claim of fraud, then you settle my bill of 200,000 Rand for damages. That's my damages claim against you just for your inference. And then you get it, then you give them a further 10 days to cure. And then their final 10 days, and they haven't done anything by there, you go to court and you file for summary judgment on your banking process. That's what you do.
Sorry, they're going to want to settle out of court because they wouldn't want any of these cases as an example.
Right, yes, they don't want a precedent set normally, but that's why they would. We had this issue here now recently with the judicial process in the court in Auckland, where we sued a third-party entity being Jayco, which is a provider of camper vans. They were provided a bill of exchange in settlement, and they refused to give it to the bank and process it. So they hold the can. So we sue for the camper van as well as $85,000 in damages because they haven't honored the bill. We get into court, and the judge that's hearing the matter starts mouthing off about the fact that a bill of exchange is an old, antiquated method of settlement and we don't use it anymore and all this nonsense. And we're going, listen, here's evidence that we've used one last month, the month before, and the month before. We're using them currently with banks like ASB Bank and all the rest of it. So don't tell us that it's not working. And she goes, well, she's not interested, doesn't even want to look at it. And this is a summary judgment application, which means it's not set down for an argument. It's only on the paperwork. And the defendants haven't even filed a defense in the time frame allocated. They haven't even filed. So the judge with the barrister that's representing the defendant in the matter now are working together. And she shuts everything down. So what we do is we go to the judicial oversight committee, basically. There's a judicial board, a group of judges or whatever that oversee other judges, and we lay a complaint. Now she's been taken off the matter. She's been taken off the case because of her incompetence, one, and her absolute dereliction of duty and not upholding the law. All she had to do is uphold the law, which she failed to do. So she's been removed from the case now. And they want the matter to be heard in May. We don't want the matter to be heard in May. We want summary judgment for our application. There is no reason not to have it. So that's where we are in this matter. We have another matter coming up tomorrow against Westpac. Now, this is the same kind of application I'm telling you guys that you should do. So we've taken Westpac to court now because one of our members sold his online company to another member for 350,000 New Zealand dollars, I think it is. And it was paid by a bill of exchange. We accepted the bill of exchange, presented it to the bank for settlement, and they have done the same thing. The fraud squad this and the fraud squad that and all the rest of it. And we're telling them the same thing. Listen, chaps, you're claiming there's any form of fraud. Provide it now, or we're suing you in your private capacities just for what you've claimed. And so we're in court now Thursday. Again, it's a summary judgment application. Now, hopefully they've got it through the echelons that what's happened to this first woman judge that's been kicked off the case, and they're going to act honorably. But time will tell. This is a battle. You must understand they're going to try and keep the gate closed as long as they can.
Correct. So my other question would be is if the bank turns around to sir and says, no, but this is in the form of a check. They see this as a check because I know that they will use this tactic. We no longer accept checks. How would anyone on this call or doing the BOE process, obviously there's a differentiation written up in the bills of exchange, but how would you counter?
Okay, it's not a check. A check on the face of it, a check has got an account number relative to the check that you hold with the bank. The banks own that account. You just have usufruct of that account. They own that checking account. They don't own your account that's reflected through your ID number, your tax number, or your birth certificate number. They don't own those accounts. That's the difference. So they can choose within a bank whether they accept a check or not. And they can say, well, we don't accept checks anymore. That's fine. You're not asking for this account that on the promissory note or the bill of exchange. You're not asking for their permission in presenting this format. Why? Because the account reflected that they're supposed to extract the currency from can only be done through Treasury. The bank can't do it.
Yeah.
The bank is just the conduit, the go-between. The same way you would do a mortgage application. They don't have your funds. They got to get it through Treasury. The same here. So they can't tell you that they do or don't accept a legal financial instrument, a negotiable. They can't. It's the law. They are obligated to fulfill their obligations under the law. You have, they must too.
Thanks for that.
All good. All good.
Right.
Next question.
James, we have quite a few hands up here at the moment. Okay. X, would you like to unmute yourself?
Hi, James. And you can't discharge a bill of exchange on a final judgment that's gone through the courts because it's been through the taxing master and the money's already been paid out from her account. So you can't, it's a fraud to make a bills of exchange against the judgment that's already been taxed. You'd rather go to the title deeds of your land and reconvey them. That's about the best option because right now she's sitting in a fraudulent situation by actually exchanging a bill of exchange, in my opinion, because from experience, I'll tell you, you can't use a bill of exchange on a judgment that's gone through the taxing master. When you get a bill, are you discharging or are you doing set-offs? Because it's a different process.
First of all, in a court process, even if you were inside a court process and you were at the court matter and there was judgment made against you, I've had summary judgment made against me, and I've set off the summary judgment with a bill of exchange, a promissory note, and a silver coin. So,
but before the taxing master has taxed it, I made that mistake and I learned the hard way. So it would have meant I'd have to then train a notary public to go and defend the matter. But once it's gone through the taxing master, it's been discharged. She is now going to be the secondary payment, but her account's already been, that amount's been discharged.
If they have been discharged and they're still asking for settlement, then they're not reflecting the discharge, which means the fraud is on them.
The fraud is there, but you had the
Right.
opportunity to discharge the bill before the taxing master did. That's the
Okay,
court.
but if you're claiming now that it's already now discharged after the taxing master has gone through it, so it's already discharged.
Well, that's what I'm saying. So you have that opportunity quite a long time to discharge that bill before the taxing master gets it. So they go back and forward through the judgments and everything, and they give you the opportunity to do bills of exchange before the taxing master gets hold of it. And that's why there's time frames in the UCC. But remembering that when you do go into court Who is going into court? Is the straw man going into court and suing the bank, or is your living man going in and suing the bank?
Well, you can only go through their courts as the entity that they deal with. So you would go in as the straw man.
So the problem there again is that your straw man name, unless you've done something major, it's got a crown copyright on it. So when
It
you
doesn't matter. The process remains the same. You are allowed to enter their courts, into their realm, and you can sue any other corporate entity in the same manner. You can't do it as a private individual because they can't hear you in their court. Their courts are only maritime, admiralty. They only deal with corporate entities. So you go in as your corporate entity and you sue another corporate entity and bind them under the acts and statutes that you're wanting to. You can't go in there as a living man or a living woman.
But your corporate entity is crown copyright. So the minute you go into their court, you're under fraud anyway. You're a fraudster just walking into their court. So you'd have to make, yes, you are. But your all capital name, unless you've done a secured party creditor, which actually isn't the right thing to do where we are, because there's a law against making a claim against a bankrupt entity, which is the government, which is the court. The court and the bank is the same thing. There's no separation between the two of them. It's just all crown copyright. So when
let me make this simple for you because we're going in circles. If I want to sue the bank, I'm going to go in as the agent for my all caps name, but the paperwork will be done in my all caps name. That's the entity that's going to sue. That's the only entity that can sue. So that's the entity I'm going to use. Whether they consider it fraud, whether you do, is not going to be important to me. What's important for me is seeking remedy and holding them to their acts and statutes. And that's the only method you're going to do it. If you're going to go in and say, well, I can't apply like this because this is a fraud, or I can't do this because the use, no, that's not how this works. You go and you sue the bank.
What I'm saying, James, is that when you go into court, you're a slave. You think you're something else, but you're a slave to the crown.
I don't think we're missing the point here. If that's the manner in which you need to operate to get remedy, then that's what you do. Otherwise, you stay out of court and let them railroad you.
Well, I would advise somebody to do conditional acceptance every time someone sends me anything.
They're still going to railroad you. The only remedy you've got is to take them into their own processes and hold their feet to the fire. That's what I'm saying. So you can do conditional acceptances till the cow comes home. If he's going to railroad you and do what he wants to do, your only remedy is to take them through their own court system. It's at the end of the day, it's a contractual obligation.
When you're saying you, that means the slave that's under crown copyright. Until you've removed your crown copyright, you can't be anything else inside the court. They own you.
I've just told you, you go in as that entity, copyright or no copyright. It's your only remedy. That's the process I do. If you want to have remedy, you can only get it as a corporate entity within their environment. You can't go in there as a living man or a living woman and expect you're going to get remedy because they won't hear you. The process is clear.
So let me ask you, when they send you a bill, anybody sends you a bill, who are they sending it to?
Your trust.
Which trust?
Your estate that's been created on the back of the contracts associated with your birth certificate.
And who owns that?
You're an equal beneficiary, as is the government.
They own it. It's their property.
You're an equal beneficiary. That's how it's been established.
Yes, I understand what you're saying.
I'm a beneficiary and I act in my beneficial right. My mum's the settler and I'm the equal beneficial right holder of that estate that they're billing. And I'm acting in my capacity as the agent of that estate. All right, next question.
Hey, how's it, James? How's it, Aubrey? I just also regarding the BOE process, there was mention made that we are having a lot of difficulties processing the BOEs because we're classified in a debtor status and we should be in a creditor status. If we're in a creditor status, then we'll end up being able to have our BOEs accepted and processed a lot better. along with this is it was stated that a bond should be created, and a bond basically for like around 500 million rand. Now, what happens is when we want to do our BOE, we essentially reference that bond number and we become a secured party creditor. So my question's really, is this like valid, or am I confused? I mean, I thought that the signature basically creates the wealth, and then we
Correct.
effectively just set off and discharge the bills that are sent to us. So I just want to understand if this creditor debtor status, how that works, whether we should be in a creditor status ourselves, etc., or if this has just been complicated and it's really a simple process, because I'm getting a bit confused.
All right. There is an American fraternity that do this bond that you're talking to, but
Yeah.
look at it this way. Let me give you a prime example. You go into a court, you've been taken into custody for something, and you go before a judge. The first thing that they present to you to sign, and the only thing they want is your signature, is the bail bond. That's the first thing that they want. They don't want anything else. They don't care about your position as a secured party creditor or not. Only thing that they require from you is your signature. So if that's all that they require to process a financial instrument, which that bail bond is, then it's your signature, nothing more. If you go back to mercantile law, the earlier mercantile laws that deals with bills of exchange, you'll find that all of them will speak to the fact that only thing required on a bill of exchange would be a signature. In actual fact, your signature is just because it's only your signature that appears doesn't make the bill of exchange invalid. And why do they say that? Why do they have that? It's because their legal system operates just with a signature, so that you're not made aware of everything else that's going on. So your first bill or bond is a bail bond. You sign a bail bond, which is a promise to perform in a certain manner, and they get money for it that they'll extract from your trust. And then there's bid bonds and performance bonds. The courts create a numerous amount of bonds relative to the penal sum associated with your charge. And your body is held as surety for that penal sum if you don't settle at the end of the day. And you go to jail, and they hold you for 5 years because you haven't settled the debt. In a court environment, you can ask a judge in the court, you can say, Judge, present me with your final offer, please. And it doesn't matter what it is. It could be $100,000 fine and 2 years in prison, whatever it is. Could you please present me your offer? Is that your final offer, Judge? That's how you can deal with it. Is it your final offer? And wherever that is, right, could you please present that offer to me in writing and give me a couple of minutes to go over it? And you can turn that offer, that judgment by the judge in the court, you can accept it, date it, sign it, and then on the record say, I've had a look at your presentment, I've indicated my acceptance, I've dated and signed it, and I'm now returning it to you for settlement and closure of this matter. You can do that in a court setting, even in a penal setting. Sorry, so coming to your question, secured party creditor, all it does is it shows that you have more knowledge than the man next door about the secured party creditor process and all the rest of it. And it is warranted to a point, but it doesn't stop you from accepting as an accommodating party a bill made out to your estate and then returning it to them for settlement and closure of their obligation. Doesn't change it at all. Your signature is where the power lies. Your signature releases the embedded equity in that offer, period.
So effectively, the only way to deal with guys like Joop Dekker and that is for us to basically take him to task and essentially sue him in his personal capacity. And 100%. Then from there on, we could become more successful with our bills of exchanges that we endorse and accept. Once 100%. You've said that.
He has no authority in law, at law, to dishonor your presentment. None at all. he has no authority. He's acting illegally and unlawfully, and he's trying to subvert justice, for want of a better word.
No, thanks very much, James. I appreciate you just clarifying a lot for me. That's really helped me out, and appreciate all the help you've given in the past as well.
No worries, it's all good. I hope it assists you going forward. But you guys have got to hold this guy to the fire. There's a number of you that have done bills of exchange. All of you start opening up independent matters against him and get him into court. All of you.
Yeah, absolutely. Thanks very much, James. The next person can ask their question. Appreciate it, man.
All good. Thank you.
The banking practice that was spoken about I am of the understanding that it's 72 hours when you send them the notice, and then your bill, you give them 30 days.
Yes.
And then after 30 days, you give them a late payment, 15 days. After the
Yes, and
15
then
days expired, you give them a 10 days
yes,
final payment. And then on day 0, you go to the court, whichever court it will be according to the amount. And then you do a 1-page affidavit to the judge, and you get a
yes,
summary judgment. That is my
yes.
understanding of the banking
That
practice.
is correct. That's correct, Robert. Those are the exact time factors relative to the banking process. 72, 30, 15, 10, and D-Day.
Thanks.
Hi, James. Sorry, it's actually Anthony. With the understanding that someone helped us be emancipated, their advice to us was if we emancipated, we're under common law and we can't engage in the courts. So when you say take these bankers to task and take them to courts and sue them, how do you sue them? In your strawman capacity, or how do you do it without encroaching and going out of common law?
All right. It's always best to be able to stay out of court and to make a private agreement one with another in line with scripture. But it's not always possible. But if you are going to go into a court seeking remedy, like in the manner that we're saying with this Europe character from Standard Bank, you can't go in there as a living entity under common law. Common law involves having a trial by jury. Or a trial by jury, a jury trial, and not a commercial setup. Any of these other maritime setups are all under admiralty. It's all contractual law based, and you can't go in there as the living man, so to speak, and try and get remedy, because they won't hear you. Your paperwork will have to be filed as the straw man. You know who you are, but as far as their process goes, you need to follow their process if you want remedy in their world. That's just the way they've set it up. Court is not the best place to be at any given time. But if you want remedy in their realm and hold them to the fire, that's basically the only way to do it.
So when you say sue them and push back, for instance, I mean, I've got cases against bankers for bill of exchange. I've got one against our private school where they just refuse to accept it. And we've given them copies of the bill of exchange. We've given them everything, and they just say it's basically a Facebook hoax and it's fraud. They're not entertaining it. So obviously, I have to push back. But to what degree do you push back? Because you're quite helpless. You phone the banks. I mean, I've gone to the extent of the CEO, the person of legal at every bank, and they've acknowledged the documents. They just choose to ignore it, and hopefully you go away. So.
Yes,
how do I push back
that's the key.
and sue them and take them to task? You said sue them in their private capacity. So in what realm?
When I say private capacity, I'm not saying from a common law perspective in that private capacity, but you hold them privately liable. So you're suing him as Europe, whatever his surname is. You're suing him in that capacity. So not as the representative at the bank, but him privately, like he's going to have to fork the money out of his own pocket for the damages that he's doing, because inadvertently you're suing him for damages because he's acting dishonorably, and he should know better because he's a lawyer. So he's a legal mind. He claims to be a legal mind, yet he's going against the exact law that he's supposed to uphold, and he's getting the bank to go along with it because he's their legal advisor. So he's advising them to act illegally and unlawfully. So a small claims process in your courts is about 200,000 Rand, I think it is. So you go and sue him for 200,000 Rand for damages and dishonor because he's violating your rights, he's violating the law. And you put in a one-page affidavit, you attach your bill of exchange that they've received, and you claim that he is advising the bank to violate the law, and he's not processing it. So you seek not only the courts to intercede and compel performance, but you're also seeking damages from him in his private capacity.
Okay. So excuse my ignorance, but how do you then sue him? Because I was advised to go to court and get a case number. I go to court and they look at me like, what are you doing? So I said, look, I'm in my private capacity. And they're like, oh, well, no, you need to issue a summons first. So my understanding is if I start issuing things like summonses, which she said you can Google or go to legal aid. So she first thinks I'm poor and I can't afford a legal representative. So she says, go to legal aid. I said, no, I'm not going to legal aid. Oh, well, then go to Google, get a summons, create your own document and serve it. But my question to you is, if you do that, are you now falling under civil law and not common law? And how do you sue them then?
100%. The process is a civil action. So you're not doing it under a common law process because we don't have common law courts. We have civil courts. They're not common law courts. Common law courts are by the people, we the people, but the courts that you're operating under are civil. Whether they're criminal, they're criminal civil. It's a civil matter. So that's the process that you're going to be using. You're going to be using their civil process, and there are forms that you can get to open up. You tell them you want to sue somebody that owes you money, for instance. What are the forms that you require to process by the court? It will be an affidavit. It will be a summons process, and he's got to be served the documentation that goes before the court, and the court will give you a date and all the rest of it. So the court will provide it to you, but you're not going there as a common law man. You're going there as the agent to your trust. Basically, you know who you are and who you aren't, but you've got to use their process to get remedy. You can't go in there as a common law man claiming you're a living man and all the rest of it. The court's not going to hear the matter. They can't speak to the living. They can only speak to the corpus. They can only deal with a corpus, and it's a civil matter. So, yeah, unfortunately, but that's the process. So if you want to hold you up, feet to the fire, that's the process you've got to follow.
Okay, because I've got a similar problem from like the lady in Cyprus, where I was sent my first notice, second notice, and third notice, only to find out that behind the scenes, the liquidator spoke to some chums of his and did an illegal auction, and my property's been auctioned behind my back without my consent. And now I got to go to court to get an eviction notice against me. So now I've got to obviously go there as living man.
No. You can go there as a living man, but you must remember the action is against your corpus. It's against your estate. That's the action. But notwithstanding, did you provide them a bill of exchange for that settlement?
Well, not yet. So we're busy right now, hopefully by tomorrow or Thursday, to have a UCC1 bill of exchange ready. So the plan is to have that when I go to court and say, well, I'm not the debtor. I've always been the creditor. So how did this process ever happen?
Yeah, or you can go into court and you can, have you got a birth certificate?
Yep.
Right. On the back of your birth certificate, you can endorse it for the case number, make it payable to the clerk of the court, and instruct her or he to act as a trustee in the matter and to settle the obligation on your behalf, and you're presenting them with this financial instrument to do so.
So on this process of the last 3 months, we've been issuing through this liquidation and sequestration process, the attorneys for the bank, we've been sending them notice saying, prove that you got copy of the bond, the title deed for the property, which we know they haven't got, and prove that it's not securitized. We've been sending them all these notices, which they've been ignoring. So they've ignored everything, and they've just done their own thing, which we know it's a scam. The banks, like I said, the banks are the cause and the banks are rotten. They're the biggest gangsters. So I've got a lot of information, but to go and stand in front of a judge, it's ugly to say, but they're pretty much all corrupt anyway. They work, in my opinion, for the banks already.
They are, and it is a difficult process, but you still have remedy. You got to equity sees done that which ought to be done. It's a maximum of equity. Equity sees done that which ought to be done. And if you have the option to settle something in equity, the courts must give you that option to settle. Even if it's a criminal matter, they must give you the option of settlement. So you can seek the judge's assistance, because he's the referee basically, whether he's corrupt or not, but he's still the referee. And you can say, Judge, I've tried everything I can to settle a matter, and I'm here again today. They've rejected everything I've sent them, or whatever the case may be. I don't know your exact situation. Here I have a financial instrument which I'm going to provide the court here in settlement of the obligation. And so you present it, you give it to the court, and appoint the clerk of the court as a trustee in this matter, with the instruction to take this financial instrument as security for the debt and settle the matter with the bank.
Because we've gone to the degree of even asking the judges and all the attorneys for the oath of offices. And
yeah, but I hear what you're saying. There's only two things you must think of which you do commercially. Only two things under the UCC which are important. You can accept an obligation, or you can reject the obligation. Those are the only two things. To accept an obligation, doesn't matter what it is, how it is presented, or whatever, you stay in honor. To reject it, you go in dishonor. Those are the only two things you can do under the UCC: accept or reject. So when you go into their environment, like the courts, and you accept the obligation from the onset, you say, I'm here to settle the matter. I'm here as a non-resident settler. That's your position. I'm here as the non-resident settler in this matter, and I'm here to settle the obligation. They've made a claim of a debt, and I'm here to settle the matter.
Okay, there's just one.
That's your position. You don't argue how much they owed or not. You're just there to settle the matter. How can I settle the matter, Your Honor?
There's just one issue, James. From my understanding, and they've showed me, they've transferred the property out of my name into the new owner's name.
Okay, but that's, I don't know the exact process of how they've done that. But if you see, this is the thing. To play catch up it's always a difficult thing. It's not an easy thing to play catch up. But if you had some form of settlement that they were presented already, I know all your questions you've asked them to try and maybe prolong things or find a leeway or a loophole to try and stand. But if you haven't presented settlement, think of what I just said about the UCC. You were, whether you knew it or not, you were in dishonor. And when you're in dishonor, you give them the opportunity to act, if that makes sense. And so, unfortunately, and I say this humbly, but unfortunately, that's the position that I think you're in, if I understand this correctly. They were never presented with a financial instrument that you could stand in court and say, well, you have received settlement. So have they taken you to court for something else now, or is it this matter in court, or how did it get to court?
Well, it was a company liquidation that went to a personal sequestration, and then it went dead quiet. And as per the law of South Africa, they're supposed to notify you that they're going to now auction your property. And that was done illegally. They've done a lot of things illegally. It was almost like it was all rigged behind the system. And now it's done, and have a nice day, you must get out. And I said, I refuse. To the degree where we started putting lanes on these attorneys.
All right, so they've taken you to court now.
Yeah, they saying I was supposed to leave and I refused to leave. They said, well, your court date is the end of March, and you are now, we're going to apply for an eviction notice. To which I'm going to rock up and say, well, what debt?
Okay, I hear what you're saying. I don't know whether that's going to fly or not, but when you get there, you can say, you can still go into that court matter and say, listen, this is my property, and they didn't give me enough time to settle. You with
Or
me?
the suitable,
I am-
yeah, they acted illegally by not
Yep,
following certain protocols.
Yep, so
Therefore,
you say that they didn't follow
Yeah.
the protocols, they didn't give me the timeframes that they're supposed to have. They just railroaded me from the onset. I would have been quite happy to settle the matter with a suitable financial instrument, but they never gave me that opportunity. Their intention was to railroad me. So now I seek the court's intervention and to allow me to settle this matter.
mm,
And to wit, I have with me a tradable bond, which I have made payable to the clerk of the court. I'm appointing the clerk of the court as a trustee in this matter, and with the instruction to take this financial instrument, which has been endorsed, to the clerk of the court and to settle the matter with the bank and to redeem whatever the court requires as far as costs go. So you make it payable to the clerk of the court and across a line and a sign about 2 inches down. I'll write an upper lowercase in blue pen on the back of your birth certificate, as long as it's original, it's not a copy. And that's the instrument that you provide the court in settlement.
because
That would be your last ditch way to go about it, because more than that, they'll just railroad you. You're on
Because
the
what-
back end of this, unfortunately. It's not
Yeah.
like your preemptive process. You're now playing catch up, and you've been in dishonor, whether they've railroaded you or not. They've processed you as though you've been in dishonor over this time frame.
Because what also got my back up now is about 10 minutes ago, the other lady brought up the issue that once it's been taxed, it's too late to do a bill of exchange. And they served me a doc last week saying that, do I give them permission to have the case taxed? Which obviously I didn't answer it.
Okay, so you've said no.
Yeah,
All right, so if you've told them no, you're not allowing it to be taxed. Well, then you've told them. This is how they're closing the door.
No, I was just worried that when that other lady came and said 10 minutes ago that once it's been taxed, you can't serve a bill of exchange either. And you obviously disagreed with it. But when I heard that, I thought, oh, I'm really on the back foot now. My window of opportunity is closed completely.
It's like the banking process. They would have done the banking process on you in reverse, basically. And you've had certain timeframes and obligations to fulfill your portion of the obligation, and you haven't. So it sounds like they've got you into a default position.
Yeah, I mean, if you speak to lawyers locally, which obviously I can't because I can talk to them, but I can't consult with them, is they did the process illegally. They're supposed to serve summons on you saying that they are going to auction your property. They didn't. They're supposed to give you
Right.
consent. They didn't.
So that's your position. Your position is you
Yeah.
weren't noticed in the correct manner. Otherwise, you would have provided them with a financial instrument to set off the obligation.
Okay.
And
then
because you were denied due process of law, you're still willing to provide them with a financial instrument to set off the obligation.
Yeah, because we're busy arranging that it's a UCC1 or whatever bill of exchange, not a local one. From my understanding, it's a
An
situation
international.
that they can't actually decline it.
They can't decline it. It doesn't matter whether it's local or international. You can't listen. A bill of exchange is considered as being cash. That's what a bill of exchange is. It constitutes being and should be treated as cash. It's not monopoly. Well, it is to a point because the fiat currency is not. But it's supposed to constitute cash. They're supposed to treat it as cash. We have setups here in New Zealand where, say, for instance, WINS, which is it's a government department that deals with those that are less fortunate, and you go in and you get assistance, government assistance, and all the rest of it. And on the back of their paperwork, they consider promissory notes and bills of exchange as cash assets. So again, it's a cash asset. It has value in their realm, and it should be treated as such. It's like a cash check. You could present a cash check for payment for a car, for instance. They release the car to you, take the car, they put the cash check in their drawer, and they don't bank it. Can they claim that you haven't given them settlement? No, they can't. If you took him a briefcase full of cash, which is just a briefcase full of promissory notes, and you presented it and they gave you a receipt for it, then claimed in 2 weeks' time, well, you haven't settled. We don't accept this. It's not settlement. No, they can't. They can't do that.
So the problem is, James, is it's society, how they've been conditioned. They're conditioned that cash is right, anything else is wrong. So going back to my kids' private school, we gave them a bill of exchange. The principal looked at me like, this is a Facebook scam. She's like, no, what are you talking about? I said, well, yeah, here's my computer. Let's Google it. It's a legal form of payment. No,
Yes,
sunshine.
but
No,
you
sunshine.
see,
She says, you can go whistle. So I said, no, what are you talking about? She says, well, I'm not going to do that. So I said, why not? It's legal. She says, well, then you take it to the bank. Therein is the
No,
problem. The
no,
bank
no,
avoids,
no.
the rest bank avoids, everyone avoids me.
Okay, but if you got instruction from the school to be able to, because normally what the banks say, you're not the client. The school must deal with them. But if you get instruction from the school that you can deal directly with the bank, then you take it to the bank with the instruction that they must process this through Treasury and put the school into funds. There's the authority to act.
Okay, so we've done that, but now the Reserve Bank, Treasury, and FNB, they just all ignore you. Ignore me completely.
All right,
And the problem also is, James, is till the funds are in the account, the school says you can go whistle. So now there's a bit of pressure. Yeah.
I understand that. I understand that. But your position is that the bank, you've acted on the instruction of the school. You've taken it to the bank. You presented lawful settlement to the bank, which is now acting in dishonor. They haven't processed it like they should. And your obligation finishes when that bank has been presented. If you banked a check and the bank cannot find a material defect on that check, and they just hold the check, they're acting in dishonor. Where would that ever be allowed to happen? Or you gave them $100,000 in a briefcase and told them to bank it into that XY account, and they didn't. They just held it, but you had receipt that they received it. You would have redress against them. It's the same thing with the bill of exchange. It's a financial instrument that they should process. It's the same as them being given a briefcase full of cash or a cash check. They're obligated to fulfill their side of things and process it. So your obligation ends when you have proof that they've received it. And if the school wants to take you to court for non-payment, tell them you're happy to have the matter heard. You've settled it. The banks are acting dishonor, and you don't mind it coming out in a court of law. And then you subpoena the bank to appear as, or whoever you're dealing want to deal with within the bank, the chief financial officer, and you subpoena the chief financial officer to appear as a witness in the matter and let them explain.
It's just the frustration is you got to go to court and do this before they allow our kids back to school. Therein lies the problem.
Oh, you mean they're not allowing the kids to come to school now?
No.
All right. Okay, that's a difficult situation. So then your best bet is, as I said, you open up a case against the bank for damages, and you do it. You take this chief financial officer, whoever it is that you provided the bill of exchange to. I don't know who the entity was. Normally you would want to deal with the chief financial officer, and that's a process. You've got to sue them in their private capacity, and then sue the bank as well.
But is it from the previous gentleman on the group? He said it's what, 72 hours notice. Then is it 30 days and then 15 days?
Yeah, but
That's
not,
a banking practice.
That's a banking.
That's a
process.
banking
That's a
practice. Let's just cool down first. We've got to understand we are dealing with the law, land, air, and water. So those are the three things we are dealing with. The bill of exchange is in the water. Once you've done the bills of exchange and they've rejected it, you've got in the bills of exchange a protest option that you've got to run. You've got to protest the bill.
No,
Okay.
no.
You understand me?
No, Robert, it's not like that. It's not. There is a protest where you use a public notary, but it's not in our instance. It would be, for instance, if we presented a bill of exchange to go from a account within the bank, for instance, and that was dishonored. Then
No, if the bill was dishonored, if it was rejected, then you've got the process of protesting the bill. Am I misunderstanding it, James?
Yes, yes. And why
You
would
read the
you
bills. If they
the protest
reject
is-
it, they in dishonor. And then you've got the protesting of a bill that you do that. And when they take you to court, all your paperwork is up to date, and the judge must just give you a judgment that the bill has been settled. That's my understanding of it. Maybe I misunderstand it. I'll go reread the Bills of Exchange Act. But you're dealing with three different jurisdictions here. When you are settling it against your 60 kV trust, you're dealing with the ecclesiastical side because you're dealing with a trust. And you as a living man, the agent, you can operate in all three jurisdictions. Am I incorrect in that?
No, you're correct. It's a trust matter. You're the beneficiary, and they the trustees.
Exactly.
You're acting as
exactly. So we
you're
are. When you go to court, they are putting different hats on. I've had it in my APSA case that the judge runs out the court, then he comes back as something else, and I didn't pick up on it because I was too. I didn't have enough knowledge at that stage. But he was coming back as a different with a different hat on. Then he was talking ecclesiastical words. Remember, jurisdiction means juris, which is the right law, and diction is the words. So you've got to pay attention to what words they are using to understand what hat the judge has got on now. And you've got to understand that once you've settled the bill, it's settled. Once they've received it, it's settled. Doesn't matter what the bank says. It's over and done with. It's you paid the bill. Am I correct, or am I?
That's 100% correct. Once they've received the bill, once they've received the bill of exchange, then your obligations cease, and that's reflected in the UCC 3-603B. It's very clear. So if you read UCC 3-603B, it couldn't be clearer. And not only that, you have recourse against them. But when you protest a dishonored bill of exchange, that's my understanding in the protest portion where you record your protest via a witness process through a notary, a public notary. It's not because we don't need to protest the fact that they dishonor it. We don't need to. It's got no skin off our nose that they don't process it. It's deemed settled. But in the old days, bills of exchange would be provided to somebody, and then they would take it to the bank to be extracted out of an account that was held at the bank, like a check, for instance. And when that bill of exchange was dishonored and there wasn't the funds in the account or whatever, then there was a process of using a public notary to protest the fact that it was dishonored, if that makes sense. That's my understanding, reading that portion of the act of protest. But we don't, as the creator of the bill of exchange presented to the bank, we don't go protest the fact that they dishonor it. We just sue them in their private capacity if we want to, because we're not protesting anything. They just then dishonor, and we're suing them for damages, if that makes sense.
If I can maybe just jump in here and just explain, Robert, I think you must just look at that section of the Bills of Exchange Act. Normally, protesting is reserved for the holder of the instrument, which is the guy that receives the instrument from you after you've issued it. So they would be protesting these instruments, not us. They as the holder have a specific duty to present for payment and to do all these things. But when the bill is then dishonored, they then have the process of protesting, not us.
Okay.
Yeah.
Thanks.
And then you're minimizing your liability in any event when you've signed it conditional UCC 1308 or sans recourse.
Like one last comment quickly, coming back before we had this discussion with Robert. So I understand the process of suing the bank directly and holding the CFO liable. I understand that process, but like what Anthony and I are saying is we have this issue now where they aren't accepting it. And obviously we're on a bit of a timeline because they've basically said my kids can't go back to school until they receive an EFT payment. So we've said to them, we've settled you with a bill of exchange. You're not accepting it.
They're in dishonor.
But so they're in dishonor, but they still refuse to allow my kids back at school. So what is the quickest form of recourse there? Because my kids can't sit at home for 3-4 months while we sue the CFO of the bank.
Or the school for that matter. It's a difficult
Yeah.
one. I can't answer that to you. I don't. I'm not in a position to tell you what to do and what not to do. But if there is dishonor, there must be remedy. So the only way to seek remedy is through the contractual obligations associated with an offer, which was the invoice from the school for educating your children, and your acceptance thereof and the presentment of the bill of exchange, which they have dishonored. So the only way for recourse is to get that before a court and have them compel performance on behalf of the school. That's the only thing that otherwise there is no, you're only going to get effect through a legal process. It's unfortunate, but that's just the way this is. You've got to remember, you're dealing with something that most people have no understanding of. It's foreign to them. They think you're just taking a wild chance, and
Yeah,
they're
they
going to
think
stand by that until they're educated by somebody within the legal system, like a competent judge.
Okay, thank you very much.
Would you like to
Thank
unmute
you.
your mic?
Hi there, thank you. Just a little snippet that may or may not help Rania. I was watching a David Strait video, and when they take their children, this is all American, but I'm thinking this might help Rania. When they take your child from you, the child services, they are stealing your child. When they tell you to go buckle your child up, you're giving your consent for them to take your child. That's the act. You buckling up your own kid in the car. So they're stressed. You must come and sign for your BOE and come take it back. It's worthless. Really? We know signatures are very, very not worthless. It's quite the opposite, in fact. So they are wanting her to come and sign, and they're trying to trick her by making her take away the BOE. So I know diddly squat about all of this BOE nonsenses, but it sure stinks. I think they're trying to trick her into taking that instrument away. So discuss.
Yeah, I would agree with you. You don't sign for it. You don't take it back. It's valid settlement, and they should be compelled to tell you what is materially defective in the instrument that they've been provided. Whenever they say that they don't accept this or they don't accept that, doesn't matter who you're dealing with. Your first question should always be, can you please show me what the material defect is that you're referencing? And if you can show me, I'll be happy to remedy it, cure it, and get it back to you as soon as possible.
And they'll make money on that signed instrument. The minute you sign anything, they're making more money of it. So they're sending you home empty-handed, in debt, and they're making money. So they win both ways.
I just want to ask, if you now need to take Mr. Europe from Standard Bank and put a lien on him or take him to court, where do you get his ID number from? How do I, as an individual, get a CFO's ID number?
I don't think you need his ID number as far as the process goes. You just need his all caps name, where he's at work, where he works, and he'll be served at his place of business the summons to appear in court and what the process is.
Thank you. Thank you very much.
James, I've got some questions in the chat box here.
Yep.
What are material defect examples of BOE?
All right, so it would be the same as a check. A material defect would be the numerical value of the bill. Say, for instance, it's 100 $100,000.17, and your written portion doesn't reflect the numerical portion, and you only wrote $100,000 and you didn't add in the 17 cents, that's a material defect. If the date is incorrect and you've made it for February 28th of February 2025, it's not 2025, it's 2024, that's a material defect. It would be similar to a check, the same mistakes that you would make on a check, where a bank would come back to you and say, listen, you've made a mistake here or there, and they'd show you and say, right, you would fix it, you would countersign where you've corrected it, and then you would send it back to them, and then they would process the check. It's exactly the same process. If there is a material defect, they must be able to present you with what it is, refer to it in your bill of exchange you provided them, and give you suitable time to cure the defect and get it back to them. That's the process.
Great, thank you. Okay, we have, if you have to use your birth certificate as a BOE, the original.
Yeah, that's why you get multiple. Every time you can buy multiple copies of a birth certificate. I buy them at 10 at a time. It costs me about $40 odd, and you can use them basically as a check in a court environment, like a bill of exchange. It's a financial instrument. It's on 100% cotton bond paper. It's a true bond, and it has embedded equity in it, and your signature in the back endorsing it, making it payable to the clerk of the court or the holder in due course, gives it its financial attributes that you require to settle the matter.
Okay, and just to add on to that, it says, my understanding is no two BOEs can have the same numbers.
Bill of exchanges don't have numbers. Promissory notes have numbers. A bill of exchange is just exchanging a bill. It's just accepting a bill as, yep, that's for my estate. I accept that, and you're authorizing a trust payment. So it doesn't have a number on it, but a promissory note has a number on it, and that's why you would have a ledger where you would put all of these instruments and record them, who received it, like you would a financial ledger for your company, or a ledger where you would keep record of your checkbook payments. Same process. You would have one for bills of exchange, and you would have one for promissory notes.
Okay, someone just added here, SA is 75 Rand per BC at DHA.
All right,
That's a birth certificate, 75 Rand.
All right, so you go and get yourself 5 or 6 birth certificate copies, and they want to know why. You say, well, you need them for an international commercial contract.
And the last one we have here, the birth certificate that you're completing as a BOE is the one sold. You can get more original copies from DOH. That's how I understand.
Yeah, I'm not sure where you get them from in South Africa. We get ours out of Wellington from Ministry of Birth, Deaths and Marriages.
Ours is Department of Home Affairs.
Okay, there you go. So that's where you would get them from. But it's at the end of the day, you're just wanting it because of it's got to be original. Can't be a certified copy by a notary or something. You need the original instrument, but it has embedded equity value in it.
And then one last one that's just popped up. Do you have to send an original birth certificate every time you send a BOE?
No. This is just, I'm talking about within a court setting. If you're not given a judgment by a judge or something, a presentment where you say, well, is that your final offer? And he doesn't give it to you or whatever, he just withholds it. Then you can take over the proceeding by saying, well, whether you give it to me or not, here's a financial instrument in settlement of the obligation. And I've made it payable to the clerk of the court. I'm appointing the clerk of the court, which will be in the court. You just ask her or him to indicate who she or he is. So you've made it payable to the clerk of the court for Gauteng, whatever, High Court, whatever your area is, and she's instructed to process it and put whoever it is that's making a financial claim against that's the settlement. That's the instrument of settlement, because the clerk of the court is the one that deals with treasury for the bonds.
Okay, that's great. That's it with the questions there, James.
All right. So
Are we-
what we've got is we've got this process coming up on Thursday with the courts here relative to taking Westpac to court for a summary judgment. Now, personally, I don't believe it's going to be, we're going to get judgment. I believe we're going to have the same rigmarole and runaround that we had with this other judge that was removed from the matter. But I don't mind that. I would like this to go all the way to the Supreme Court, because a Supreme Court, once it gets to the Supreme Court, they're not like the lower courts, which would try and frustrate you. There in the Supreme Court, they have to uphold the law, and this is only a law issue. It's only about the law. Is a bill of exchange a valid, justifiable financial instrument that's used and can be used in settlement of a financial obligation? Yes, it is. That's the law. So once we've got through maybe the lower courts, through the high court, which could play the same games, and we get it all the way up to the Supreme Court, I would prefer judgment in a Supreme Court setting, because that judgment can be used all over. A New Zealand Supreme Court judgment could be used as a reference the same way we reference Canadian Supreme Court judgments relative to trusts and the fact that they should, as beneficiaries, they are obligated to tell us of the existence of the trust, etc., etc. So if we don't get judgment on Thursday, we will keep moving the process up through the courts, and we'll keep you guys up to date on our processes here.
Keep us informed. That'll be great. Thank you. One other question has just come in here, James. Would like to buy a commercial property for my business. Need to expand instead of renting. What would the process be?
If you can, you've got to, well, this is, and this is not financial advice, but this is what I would do. You need to be able to purchase the property with a mortgage, pay it for a couple of months, then ask for a early settlement figure, which is we call it an early repayment adjustment quote. And then once you've received that early repayment adjustment quote, either give them a bill of exchange or a promissory note for that value. And then once they have set that off, you have a property that's unencumbered financially.
Okay, thank you for that. Would you like to unmute your mic?
Yes, sorry, I just had a quick question. So you're saying to buy a property with a bill of exchange, you first need to buy it in your personal name, pay a few a few payments, and then ask for a bill of exchange. You can't just buy a property outright with a bill of exchange.
Well, think of it this way. You should be able to, but if you're having kickback already in the manner that you're trying to settle obligations with bills of exchange already, can you imagine how they're going to press back when you try and buy a property from the onset using a BOE? It's going to be...
Yeah, no, I can imagine it's going to be a runaround. But the thing is, how are you going to qualify for a bond if you in the situation where you basically been sequestrated? So how do you do it if you can't qualify for a bond?
Well, it's a difficult one.
So even with an international bill of exchange, you can't just straight up purchase a property.
You could by law you should be able to. This is the whole crux of the matter. By law you should be able to, but it's getting the principle, the process through a court, having a judgment in your favor, which is important, because these banks are not relinquishing their hold on having the monopoly of processing bills of exchange. This is the issue. Is it a valid form of settlement and purchase? Absolutely. But how do you give effect to it other than through a legal process? But that's what we're working towards. We're working towards a judgment here in New Zealand in the same process, the same principle, so that going forward, there is precedent that has been established that, yes, it is absolutely a legal and lawful settlement. We have our estates, we have our trusts, our SSTQ trusts, and they must action them accordingly. And That's why another thing that you could always file in every process of paperwork going forward is that judicial notice by Supreme Court Justice Gorsuch, which I put in the chat a while. It's a one-page document. Now, a judicial notice constitutes evidence in any matter. And what's put forward in that one-page document is evidence that all of these legal processes that we are forced to be processed under are illegitimate, they're illegal because they circumvent the common law. And we are entitled to proper remedy, equitable remedy, which they are not giving us. And so when you put this onto the court, any of your court documents ever, you file this with your affidavit, you refer to it in your affidavit as evidence in the matter, that in essence what's happening is the banks are denying us our right of remedy, which has been established for us, which is contrary to law. And as such, they're now acting in opposition to Judge Gorsuch's mandate, I don't know the right word, but his judicial notice, literally, where he's putting judges and everybody on notice. I would suggest you read it and use it in every application, in every possibility you can, in every court setting, because any judge that goes against your fundamental unalienable rights, and one of those constitutes having the right to remedy or financial remedy, and a bill of exchange is just that. You have the right to do that. It's been set up. Your trust has been set up to do that. And if they deny you that right, they are operating in a most malicious manner. It's calculated. It's done with intent. It's done with malice. And they've put on notice that going down the line, there's going to be remedy against them by we the people. And it's put in position by the Supreme Court Justice of the United States. So it's a very powerful document. I'd read it and I'd use it in every case I can.
James, would it be possible for you to just share with us again that document that you're referring to?
Yes, I'll put it in on the chat again on Telegram.
I'm going to attach it, guys, to the chat.
Okay, there we go. Dean says he's got a copy.
I've got a copy of it from David Strait.
All right,
Okay.
there you go.
Thank you.
Just give me a mo.
Sorry, I got distracted with the property buying with a bill of exchange. I actually had another question. Can I ask it quickly?
Yep.
Okay, so earlier when I spoke to somebody about how to stop the process with a house issue that Anthony discussed with you earlier, I spoke to a gentleman and he said to me I should just apply to the court to have my judgment or my sequestration rescinded. But then doesn't that put me back under civil law if I approach the court?
Well, if you want remedy in the realm, you have no choice but to approach them. You can't expect a remedy in the maritime admiralty setup, which is civil and contractual, if you're not going to work within it. So that's the catch-22. I know we have our emancipation and we know how to stand as living men and women and all the rest of it, but you still got to remember the court system is an admiralty contractual setup. It's a civil setup. So if you want remedy in it, you need to be able to play by their rules and their sandbox when you are playing there. And then when you're out of it and you want to stand in your autonomy, be able to stand in it. But if you want remedy in their realm, you need to play by their rules. You can't bring your rules to their sandpit. You'll get kicked out.
So would you recommend doing that anyway? If this court date is at the end of March, would you in the meantime recommend to ask for that rescindment of that judgment, just maybe to buy time?
Because what they basically say.
Well, yes, you can go in there. Why not? If you've got a financial instrument that could settle off all those obligations, being, for instance, your birth certificate as a financial tradable negotiable instrument, then why not? Go before the court and say, right, I have an instrument here that I would like to present in full settlement of whatever financial obligations have been made against me. As the non-resident settler and the agent in this matter, here I'm presenting the instrument. So I want the sequestration set aside because here is the settlement. It could be at the 24th hour. It doesn't matter. Here is the settlement, and let them try and dishonor that. If they do, if the court dishonors it, you apply to a higher court. You'll get it higher up the food chain, where it will be shown and seen that they can't set aside the sequestration because you have given valid settlement. And that's all they're looking for. They're just not teaching you how to do it, but that's what they want.
Because, James, the recommendation today was, if we do that, then this potential eviction court case end of March won't happen. It'll fall away.
Well, there you go. So if you have settled the obligation, how can they evict you from something that you have settled?
Okay, so do you apply to the
As it
court?
stands,
The
as it stands, you're in dishonor. As it stands, however you got there, you're in dishonor, and they're processing according to that dishonor. Whether you have the time available
So you've got to go to
to
a high
set
court
aside, to set it aside is another matter. Only you will be able to know and see and be able to do, but you have the instrument. A birth certificate is a valid instrument, properly endorsed and presented. There's no reason why you can't stay the execution, so to speak, because you've provided settlement.
So you go to the court that granted the sequestration, you go to the registrar of that court.
Yes, you open it up where you were at, and you ask for it to be set aside. What do you need to do to have it set aside? You have a financial instrument that will be able to settle all debt.
Okay. And then can I just last question, sorry. I know Abri has done we do have a cover letter of the Bill of Exchange that Abri did, but I've noticed that yours is different. Yours references the UCC and it has a different format on it. Is there a template somewhere that we can just look at?
I think there was one put up in the Telegram chat, which I did for a chap from Cape Town, that there isn't a right or wrong way, so to speak. You got to fulfill certain obligations. You got to date it, sign it, accept it unconditionally, and return it. Indicate who you're paying if you can. So that's the format that I created for that chap. I don't know how it changes to your format. I haven't seen, I think, your format yet. I think we were still waiting for that chap who had success in January to provide his format as to what his looked like. But I don't think the one that I did for this chap in Cape Town is much different to what you guys do. The only reason why we reference the UCC is because it's binding on all. It's Uniform Commercial Code, and we're operating within.
And this one for this the City of Cape Town one, was that one successful? Was it accepted?
No idea. It's a recent thing, and it can take up to 90 days, I suppose, for them to process it and show set off. So I don't know whether it's successful or whether he's still going to be battling this in a court setting going forward. I don't know. It's too early to say, but I can tell you this much: you're going to start having press pushback. If I listen to that guy that did have success, and the fact that they're now telling him, they've now revisited the matter and they've written him and said they're now going to pursue him in his private capacity for the debt that's already been settled, mate. That's jail talk on their part. That would constitute fraud on the bank and absolute intimidation, criminal coercion. They are breaking so many crimes just in that threatening letter. So I would take them to task immediately as that guy, whoever that guy is. Give them 10 days to justify their claim of XYZ having already received full settlement, or you will be seeking summary judgment against them for damages and what they're trying to do. That's what I do immediately. I wouldn't let that lie at all. I would grab it while it's still hot, put them on notice with your intent to sue them for damages, because they have received full and final settlement and they have shown actual set off of the obligation relative to the instrument they were provided. So they can't even come back now and claim something else in their paperwork, because his statement is quite clear and shows very clearly how they've set it off. And they didn't set it off until they had received the financial instrument that they were provided.
And James, that opens up a damages claim from that person.
Absolutely, absolutely. Just the fact that they threatened him, that they're now going to come after him for a debt that they have got legal and lawful settlement for, and have already set it off, and their statement reflects it. Man, that's criminal coercion. That's another ball game. That's fraud. That changes the whole dynamic. And I would put them on notice immediately that they must justify immediately the claim, because your intention is to now sue them for defamation and damages, tort and trespass.
There's that wonderful word, tort.
Yep, it's a tort against you. It's a trespass against you. And they're using what constitutes criminal coercion and misrepresentation to try and hold you liable for something that's already been settled. It's a no-no.
Dean has sent me the document. He can't get it onto the chat here, so I will put it up on the study channel under the Bills of Exchange category.
Yep, you can put it in any category, even with your IRS or Inland Revenue or whatever it is. Whoever you're dealing with in the public realm, bankers, government, doesn't matter. They all act in fraud. They're all part of this fraudulent fiat currency construct. So I would put them all on notice. Every bit of correspondence that I ever deal with, I send that out as a reference to the body of my letter or correspondence or whatever. I put it in there just to put them in, bring them into the awareness, put them on notice. Is there any other questions? Anybody want to cover anything else before we go?
No, James, I think I'm good. My side, I just see that we're going to have load shedding within the next couple of moments. So I think if I disappear, then you know why. But thank you
No
for
worries.
your time. Thank you for your trouble.
I'll be a quick question. That instrument that we were speaking about, that we spoke about this issue earlier just before we started. If we can have a copy of that instrument, notwithstanding his issue that he's now had with the bank, and we need to assist him speaking to this corrupt individual within the banks and putting them on notice, and hopefully getting him a court process going as quickly as possible within the next 2 weeks.
Yeah, I'll make contact with him again, and I'll ask him if he can please provide us with that instrument. But yeah, I'll have a chat with him in the morning.
Okay, and then tell him basically what we're talking about here relative to the fact he puts them on notice, and with the intention of suing them for damages, just for what they've intimated.
Yeah, no, I'll do that. Okay.
And the lady with ABSA that had the issue with ABSA, the same thing. The ones that have intimated their fraud squad or whatever could possibly constitute whatever. They must be done the same thing. They've got 10 days to provide evidence as to their intimation, or they'll be sued as well for damages.
Thanks very much. Really appreciate it. And thank you everybody for attending, and have a lovely evening for everybody.
All good. Thanks for having me. We'll catch up later. Maybe next time we can speak to private agreements and how you can bind these guys that you're dealing with before you get into a court matter in the private. As far as a private agreement goes, publish it, create your court of record before you even get into court.
That'll be brilliant. That'll be great. Thank you. Much appreciated.
All good, guys. Blessings from New Zealand, each and every one of you, and we catch up later.
And
Thank you, James.
Thanks, guys. Well done.
Thanks.
Thanks.